The U.S. Supreme Court has agreed to hear a case involving a New York law that limits a person's ability to carry concealed guns. Observers say the decision in the case could set up a landmark Second Amendment ruling at some point next year. Joining us with reaction is Greg Wallace. He's professor of law at Campbell University, and among his specialties is the Second Amendment. Thanks for joining us.
Thanks for having me.
So before we get into the details of the case, I understand this could lead to the first major ruling dealing with the Second Amendment in more than a decade.
Yes, it could. The Supreme Court decided the Heller case back in 2008, and that was the case in which the Supreme Court declared that the Second Amendment protects the individual right to keep and bear arms, not a collective right or a militia right, for the purpose of self-defense. Now, 2 years later, the court in the McDonald case said that the ruling in Heller applies to the states through the Due Process Clause of the 14th Amendment. Heller involved a D.C. regulation that, and since the District of Columbia is a federal enclave, the court had to go back in another case and decide whether that Second Amendment right is to be incorporated against the states. There was a case in, I think, 2015, I believe, the Caetano case, in which the court held that stun guns are considered firearms or weapons, arms that are protected by the Second Amendment. And then, of course, almost a year ago to the date here, the Supreme Court denied or granted cert in a New York case, and then New York took some action. The case involved a challenge to a law that prohibited carrying firearms out of the city of New York. And the New York, after the case went up to the Supreme Court, took actions to moot the case by repealing the law. And the Supreme Court at the time, instead of ruling on the merits of the case, simply dismissed it as moot. So yes, the long answer to your question is this is the first major case dealing with the scope of the Second Amendment in a dozen years.
This case is called New York Rifle and Pistol Association versus Corlett. I assume I'm pronouncing Corlett correctly. What should we know about this case?
Well, the Heller case back in 2008 dealt with a challenge to a D.C. ordinance that prohibited the possession of handguns in the home. And what some lower courts have done since that decision is to confine Heller to its facts. That is, this right to arms really only applies in the context of self-defense in the home. Now, what the court has done in this case is to raise the issue of whether the state can constitutionally prohibit what we might call public carry. Now, in New York, anybody who wants to carry a gun outside the home and has to show some good reason for doing so. The reason has to be more than just, well, I might be involved in a crime, or I might need a firearm for self-defense. And so what you have in this case is what we call a may issue state, that New York is a may issue state. If you want to carry in public, there's no open carry in New York. So the only way you can carry a firearm in public is to carry it concealed. But if you want to do that, you have to show some sort of good cause, some sort of reason that goes beyond the usual risks that people take by going out in public. And that's the law that's being challenged in this case.
Now, I understand the Supreme Court justices considered taking up this case in 3 separate conferences, meaning it came before them and they said, are we going to take this up? Took them 3 times to decide that. And then when they did, they decided to limit the issue that's going to be considered. If I understand it correctly, it's going to be whether the state's denial of the individual's applications to carry a gun outside the home for self-defense in and of itself violates the Second Amendment? First of all, did I get that somewhat right? And if so,
Yes, you did.
and if so, what is the significance of that?
I don't think the fact that they held this over for three conferences really we need to read much into that. There were about this time last year. The Supreme Court denied about a dozen petitions for review that some of them had been held for over a year through several conferences. So I think the court is looking for a case that it can clarify and answer a lot of the questions that were left unanswered. As to there was a bit of a curiosity, as you said today, that the question presented to the court by the petitioners was different than what the court actually granted review on. And several of us have been sort of scratching our heads wondering what that may mean. But I'm not so sure that it carries any significance when you think about that. The only way you can carry in public in New York is by concealed carry. And since there is no open carry, that's not at issue. The only way you can carry in public is by concealed carry. So the rewriting of the question to include the words concealed carry may simply be nothing more than something of a clarification about public carry. Now, the Ninth Circuit sort of screwed all this up in a couple of decisions in the last few years, where it said, well, there's no constitutional right to concealed carry, but we're not going to address the question of whether you can, that means there must be a constitutional right to carry in public. And then when that came up before the court said, well, there's no constitutional right to carry in public, notwithstanding, our earlier decision. And so in effect, when you combine those two decisions, you have no constitutional right to carry either concealed or to carry openly in public. Now, since that's not the same option that's presented in New York, since there is already no right to carry in public there, this case only addresses the concealed carry issue, but that's tantamount to carrying in public. And that's really what the petitioners and I think a lot of Second Amendment advocates want to see. They want to see the court weigh in on the question of whether there is a constitutional right to carry a firearm in public.
You've already referenced this, but about a year ago, the Supreme Court had a gun case, decided it was moot because of the law change in New York. Then shortly afterward, there were 10 different gun rights cases that the court could have taken up and decided not to take any of them up. What do you think is different now?
Well, I think that the big difference is that you have Justice Barrett on the court. Prior to Justice Barrett coming on the court, the swing justice was Justice Roberts. And there have been a lot of indications over the last 3 or 4 years that Justice Roberts is moving much more to the middle, much toward that kind of position that Justice Kennedy had on certain issues. And I think, frankly, the 4 justices, and it only takes 4 justices to grant a petition for review, a petition for cert, as we call it. And I think they had the 4 votes to grant cert, but I think those 4 justices were concerned that they just didn't know where Roberts would go with another Second Amendment case. And so now that Justice Barrett is on the court and her past record, her past rulings have been much more consistently pro-Second Amendment, that they think that now Chief Justice Roberts' vote is not really relevant. I mean, you've still got, even if he sides with the liberal wing of the court and votes against this, you've still got 5 votes in favor of a pro-Second Amendment decision.
We've mentioned earlier that the last big cases dealing with the Second Amendment were the Heller case and the McDonald case, dealing with D.C. and then dealing with the states through the city of Chicago. What have various justices said since those rulings, whether it's in responding to a petition or dissenting on something? What have they said that offers you some clues about how they might react to this case?
I think that it's fairly clear that Justice Thomas, who has filed several dissents from denials of review, I think Justice Thomas, Justice Gorsuch, I think Justice Alito are pretty much in favor of clarifying and keeping the scope of the Second Amendment broad. The other two justices, of course, we don't know anything about how Justice Barrett is going to rule, except based on her lower court rulings. And she did rule in a couple of Second Amendment cases that favoring the right to arms. The other justice that's something of an enigma, I think, is Justice Kavanaugh. Now, he agreed last year when the court dismissed that New York case as moot. He wrote that he agreed with the decision, but he was concerned, like Justice Thomas was, that lower courts were really turning the Second Amendment right into sort of a second-class right. So I think it's fairly confident that you've got 5 votes up there to maybe in this case reverse the case and make a strong statement about the applicability of the Second Amendment to carrying firearms outside the home.
Well, this case, New York Rifle and Pistol Association versus Corlett, will come up in the next fall term of the Supreme Court, which means we probably would not see a ruling until maybe a year from now, or even a little bit later, June of 2022, perhaps.
Yes.
We know one person who's going to be watching very closely as this case moves forward is Greg Wallace, professor of law at Campbell University. Thanks so much for joining us.
Thanks for having me.